it was a voice vote, and I did not participate in the voice vote. But I insisted that I be counted as a member of parliament present to constitute the quorum before a decision was taken. Indeed, this decision affirms that position that I took. I find that very refreshing. Soon after that decision, a former Speaker of Parliament called me, and he said, I called you to congratulate you for being bold to take this decision, because that is how the frontiers of the law are expanded. Matters that have never arisen are now in the fore because of the numbers we have in the chambers. So anytime there's disagreement, as I've said already, I will interpret the rules and the law as I understand it. I encourage people who disagree with me to boldly state their position, and if need be, refer to the appropriate body, like the Supreme Court, to guide us. As of now, at the end of it all, we are being guided. What we have not done before, where the way was not clearly marked out by our own standing orders, has now been cleared by the Supreme Court, and I think it will help us advance our democracy and our practice in this chamber.
What do you make of having ordered to be struck off from the standing orders?
Right.
How does that strike you?
Well, let me say that we had a long argument between myself and the majority leader. He argued that, in his view, a deputy speaker presiding was entitled to a casting vote. I said that, reading the constitutional provision, I tend to agree with him, but I will not make that pronouncement because it is not so clearly stated in the standing orders and the Constitution. I'd rather that a body other than me would make that declaration. So I'm very glad that indeed that clarity has been given. But I'm not surprised. The text of the Constitution was very clear. And even Article 1093 was clear that you shall not retain the original vote. Whereas in the case of the Speaker, it said you shall not have either original or casting vote. When it came to the deputy speakers, it said you shall not retain the original vote. The natural consequence was that you would have a casting vote. This decision of the Supreme Court appears to affirm that position that was strongly argued. I agreed with, but I just stopped short of making that declaration because I thought if we had to make that declaration, I would have preferred that it would come from the Speaker or the House voting that it should so be. But what the Supreme Court has done, in my view, is to clear the way to remove any ambiguities in that respect.
What do you make of the argument from especially the minority leader reacting to this, that this really amounts to judicial interference in the work of the legislature?
Well, his interpretation is his. What I know is that this matter was put to the Supreme Court to interpret the Constitution, and standing orders was pitched against the Constitution. The Supreme Court has concluded it is the only body that the Constitution has given the mandate to interpret the Constitution when there's disagreement as to what it means.
There are claims that they simplify the judgment to mean that a referee being given a jersey to play for one side in a game. What do you make of this?
Deputy speakers, referees, in fact. You cannot be a deputy speaker unless you belong to a side of the House, unless you're part of the team. So that analogy, in my view, is wrong. We belong to teams. Indeed, the Constitution, and I think under Article 96, was very clear. You must have been sworn in as a member of Parliament before you can be elected as a deputy speaker. Secondly, it is expected that the deputy speakers will belong to one side or the other. It is not a question of being a neutral person, no. But all persons, once presiding, you are required to be impartial. Impartial. And that is what speakers are required by law to do.
And for me, the minority argue again that Article 102 is clear. Apart from the person presiding,
members can form a quorum. So if you are presiding, you cannot form a quorum to transact business. How do you respond to that as well?
Why are we relitigating the matter before this Parliament? That point has been made at the Supreme Court, and the Supreme Court has very clearly ruled that that interpretation is wrong. Indeed, that was my view, that that interpretation was actually taking one out of the many scenarios in which a presiding member would be counted or not counted. Indeed, in this same House, that ruling had been made by Speaker Ajahu, and the ruling is very clear. Indeed, the current Speaker argued in support of that ruling at the time. So I'm surprised that people are changing the positions, but whatever misunderstanding that people had, I think that the Supreme Court has cleared it, and we are all bound to go by
Let's talk
the
about
interpretation.
the implementation of this particular judgment. Practically, if your second deputy is unavailable and you are in the seat, how are you going to exercise that right to vote?
Well, why should that be an issue? I will just be counted as where I place my vote. There's no need for any getting up or anything. I vote here or here. Indeed, I've observed proceedings in the British Parliament and the American one. The person presiding will say, add my vote to ayes or noes. And I think that practice should suffice.
So you exercise the vote in the
The
chair.
yes. Extended to you as deputy speaker. The people contend that some argue that because of this particular judgment, it means whether you're presiding or not, you remain a member of parliament for the fight. Those courtesies can then be taken away from you because you are just like any other MP.
I don't know how they come to that conclusion, but I'm inviting all of you. Yesterday's proceedings is available. Check. My name is there as the person presiding, and I also count members present. My name is both there as a member present and as a member presiding. How is it different from the decision of the House? I think that we should accept that partisanship is what influenced the side people took. That is why we both moved the matter out of our partisanship arrangements and put it in the court where all arguments are heard, the decision is made. We should be guided by the decision of the Supreme Court.
Finally, you are a lawyer in a very good standard. Finally.
Can this be the last question?
Yes, last question. You are a lawyer in a very good standard. The minority has argued that this is a judicial support for the controversial event. Nothing more, nothing less.
Well, I don't know what ruling that has gone against the minority in particular, that they have not bastardized. It's embarrassing in my view. Even when they have gone to court and they have failed to provide evidence, they still call their own failure to provide evidence to support their claim as an aberration. They're entitled to their view. When it comes to legal interpretation, I really don't have hard feelings about them. We read the same language, but people interpret them differently. That is why there's often disagreement as to what is the meaning of A or B. Sometimes, how we have grown up, the things we have experienced over the years, influence how we interpret things. And so when the final judgment is given by the body that has the power to do that, well, what other people think does not matter. What becomes the law is what is given by the body that has the authority